Okay, here we go. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today because you have a case in this court. The case that you have in this court is a criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are your most serious type offenses, whereas your misdemeanor offenses are commonly referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about is the facts and the punishment that a person can get if they are convicted of committing the offense. Felony cases are divided into 5 categories. The highest felony that you can have is a capital murder. Then it goes down to a first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If a person is convicted of a state jail felony, a person can receive a minimum of 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. Person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, the range of punishment, if convicted, is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, the offense that you have in this court is a misdemeanor case. It's not a felony case. Misdemeanor cases are divided into 3 categories. And we can start at the top. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. Class C misdemeanors are those cases that are normally handled in the JP court or the municipal court, the city court. The only way they get to this court is if a person gets convicted in the JP court or the city court, and then they file for an appeal. Then the case comes up to this court, and then the punishment range will be the same. The punishment range for a Class C misdemeanor, if convicted, is by fine only. You only can be given a fine. For example, a Class C misdemeanor will be a case where a person is speeding, a person is not wearing a seatbelt. It could be a case where a person inspection sticker is expired, and there are a whole host of other Class C misdemeanors, but you cannot be given jail time. You only can be given a fine. However, if you fail to pay the fine, then the court can convert the fine to community service if you're indigent. And if you fail to perform the community service or pay the fine, then the court can issue what is called a capious pro fine. That means that it's a warrant for your arrest for the fine. And if you can't pay the fine, you'll be required to sit the fine out in jail. And every day that you spend in jail, on this case, you receive $100 a day that will go toward your fine and court costs. All right. Now, the next misdemeanor offense is a Class B misdemeanor offense. If you're convicted of a Class B misdemeanor offense, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail and a fine that does not exceed $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment minimum of 0 days to a maximum of 365 days, which is 1 year in the county jail, and a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are 2 types of probation that a person can get. And basically with probation, you don't go to jail, you'll be serving your punishment out in the community. So for example, there are 2 types of probation. One type of probation is called unadjudicated probation, and the other type of probation is called adjudicated probation. The difference between the 2 is with the unadjudicated probation, you will not have a conviction on your record. And if you successfully complete the unadjudicated probation, your case will be dismissed and you may qualify for a non-disclosure. A non-disclosure basically means that we cannot disclose the fact that you were on unadjudicated probation to the general public. However, there are some state agencies by law who can find out whether or not you receive unadjudicated probation. For example, the police department, they can have access to that. But basically, most businesses, if it's not governmental related, they can't have access to the fact that you were on unadjudicated probation. The other thing is, the other type of probation is called adjudicated probation. Adjudicated probation means that you will have a conviction on your record. Sometimes we call adjudicated probation regular probation. However, there's something that is called judicial clemency. That means that the court or the judge can set aside your conviction and you will no longer have a conviction. Now, the way it works, you have to successfully complete the probation. They cannot have any more time left on your probation, and you have to be discharged or let off of the probation. If those 3 things happen, then the court can set aside the conviction and you will no longer have a conviction on your record. However, if you get a subsequent conviction, or if you get another conviction later on, then this case that you receive judicial clemency on can be resurrected, revived, and brought up again and used against you. Now, if you try to get a license with CPS, they can deny giving you a license. If you have a license, they can revoke or suspend your license. Now, as a defendant in a criminal case, you have rights. And one of the rights that we're going to talk about is your right to have an attorney. The clipboard that you have, the first page is titled Judge's Explanation of Rights to Defendants Without Attorney. Now, as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number 3, you may waive your right to an attorney or give up your right to have an attorney, and you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date from this court date. So your case will be reset or be set on another date to give you time to hire your attorney. Now, if you want an attorney, but you do not have enough money to hire an attorney, then you may request that an attorney be appointed to represent you. You have to fill out the proper questionnaire so that the court will determine whether or not you qualify for a court-appointed attorney. If you want to waive your right to an attorney and represent yourself, or give up your right to an attorney and represent yourself, you'll have the opportunity to speak to the prosecutor. The prosecutor is an assistant district attorney who works for the Jefferson County District Attorney's Office. you may not speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Now, the written waiver, it should be the second page on the clipboard. For those of you who would like to represent yourself, the written waiver is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You would have to read that document and then sign it. I'm going to go over that document after I finish going over the first document with you. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, that is, if you decide to waive your right to an attorney and to represent yourself, you may change your mind at any time and may request that an attorney be appointed to represent you. Now, at the bottom of that document, you'll see 5 lines. The first line states that if you want to hire your own attorney and you want your case to be reset, then you'll place your initials on the first line to the left. If you have already hired an attorney to represent you on your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left and the name of the attorney on the line to the right. If you have already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, if you want to give up your right to an attorney and you want to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, August 1st of 2023. Now, for those of you who will be waiving your right to an attorney or giving up your right to an attorney and representing yourself, you would have to read and sign the next document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And that document states that I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this first day of August of 2023 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I'm not financially able to afford counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that is your choice, then you will sign your name on the line where it says defendant, and you would date it today's date, August the 1st of 2023, on the line that is titled date. Now, as a defendant in a criminal case, you also have a right to have a jury trial. For those young people who are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to the evidence that's presented. They will listen to the closing arguments. they will decide, they will deliberate, and once they deliberate, they'll decide whether or not to find you guilty or not guilty of your charge. You also have a right to waive, which means to give up your right to have a trial by jury. And if you waive or give up your right to have a trial by jury, you will not be having 6 jurors to decide whether or not you're guilty or innocent. Your case will come before the judge in one of 3 ways. One way it can come before the judge is by way of a trial. We call that trial a bench trial. And that is a trial by judge only. So the judge will listen to all of the evidence, listen to the closing arguments. After listening to the evidence and the closing arguments, the judge will decide whether or not to find you not guilty or to find you guilty. Your case will also come before the judge. If you decide not to have a bench trial, it can come before the judge by way of a plea bargain. It can come by way of an unagreed plea bargain, which means that you and the state have not been able to reach an agreement to settle your case. Now, a plea bargain is an agreement to settle your case. If you and the state have reached an agreement to settle your case, we call that an agreed plea bargain. If you have not reached an agreement to settle a case, then we call that an unagreed plea bargain. So if your case comes before the judge with an agreed plea bargain, that is, you and the state has reached an agreement to settle your case. For example, the state may have agreed to settle your case by giving you probation, either deferred probation or unadjudicated probation. And the case comes before the judge could either accept or reject the plea bargain agreement. If the judge rejects your plea bargain agreement, at that point, you can tell the judge that you will withdraw, which means to take back your plea of either guilty or no contest. And so therefore, once you withdraw it, then you will go back to square one. Now, if the judge accepts the plea bargain agreement, and if you decide that you want to appeal your case within 30 days, you have to get permission from the judge that accepted or followed the plea bargain agreement. Now, if the judge gives you permission to appeal, your case will be appealed to a higher court than this court. It will be appealed to the Ninth Court of Appeals, which is right above us on the 3rd floor. They will review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. They can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. Or if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals, located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. What that basically means is, pro se means that you will be filing this petition without the assistance of an attorney. In essence, you'll be representing yourself. You file a petition to the Texas Court of Criminal Appeals. They could either accept, or they can either grant or deny the pro se petition. If they grant the pro se petition, they can simply find you not guilty. Or if they deny it, or they can send the case back to the Ninth Court of Appeals, or send the case back to this court and order this court to give you a whole new trial. If they deny your petition for discretionary review, at that point, then your conviction will stand. Now, I mentioned that you have a right to have your case come before the judge by way of a bench trial or by way of an agreed plea bargain agreement. The other way it can come before the judge is by way of an unagreed plea bargain agreement. That just simply means that you and the state have not been able to reach an agreement to settle your to settle your case. And so therefore you want the court to assess your punishment. And so we call that an unagreed plea bargain agreement. Now, also as a defendant in a criminal case, you have a right to have witnesses to come to court. That area over there where the microphone is in front of that chair, we call that the witness stand. And what witnesses do, they will come to court, they can testify either for you or against you. If you represent yourself or if you have an attorney represent you, you or your attorney can ask them questions. You can ask them if you represent yourself, your attorney can ask the questions. If your attorney is representing you, we call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. And that simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses in your case, because they will be calling witnesses in your case. You also have what is called a Fifth Amendment right against self-incrimination. That simply means that you have a right not to testify against yourself, or you have a right not to testify in your case. That's your Fifth Amendment right against self-incrimination. State of Texas, the government cannot force you to testify in your case. Now, you can waive or give up your right, your Fifth Amendment right against self-incrimination. And by doing so, if you waive or give up your Fifth Amendment right against self-incrimination, you will be testifying in your case. You also have a right to have what we call discovery. Discovery is a right to see the evidence that the state has against you, that they'll be using against you. You have a right to see the documents, the instruments, witness statements, your statement, if you had a written statement, police reports. You have a right to have access to video recordings or audio recordings. You have a right to have access to those things, the evidence that the state will be using against you. Now, you can waive or give up your right to have discovery, and by doing so, you will not have access to the evidence that the state will be using against you. Now, everyone that's here today for arraignment, you've been arrested and you're out of jail on bond. You're either out of jail on a cash bond, that simply means that you paid the full amount of the cash to get out of bond, to get out of jail, or you're out of jail on what is called a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail. Or you're out on what we call a PR bond, or personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance. And the reason why I brought that up is because every day that you spent in jail, that jail time could be used as credit toward your punishment. So, for example, let's say you spent 5 days in jail and then you bonded out. Well, you and the state have been negotiating. Y'all reached a plea bargain agreement. The state is offering 5 days in jail. That simply means you won't have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served. Now, if they offered 7 days in jail and you spent 5 days in jail, then you will only have to spend 2 days in jail, because we're going to subtract the 5 days that you've already spent in jail from the 7. So that would only leave 2 days in jail for you to serve. Every day that you spent in jail also can be used as credit toward your fine and court costs. You will receive $100 per day that can go toward your fine and court costs. So, for example, if you spent 5 days in jail, that's $500 that will go toward your fine and court costs. So if you and the state has reached an agreement, fine and court costs of $500, then that means you won't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if the state is offering fine and court costs of $700, that simply means you don't have to pay $200. Why? Because we're going to take $500 from the $700 and then leave $200 to be paid. Now, you'll be required to pay the fine and court costs on the day that your case is disposed of. If you cannot pay it on that day, then we can put you on what is called a payment plan. In essence, you can pay off the fine, the remaining balance in monthly installments. Now, for some people, because they do not have the income or employment, they still may not be able to pay off the remaining balance. And so therefore, the court can convert your fine and court costs to community service. And what community service is, it means that you'll be working off your fine and court costs at a nonprofit organization in the Jefferson County area. So every hour that you perform in community service, $12.50 will go toward the payment of your fine and court costs. So for example, if you work 8 hours community service in one day, that's $100 that will go toward your fine and your court costs. So in the example that I used, the person had $200 that needed to be paid. Only thing they had to do was work 2 8-hour days, and that would satisfy them paying the $200, because that'll be $200 that will go toward their fine and court costs for the 16 hours of community service that they have performed. Okay, now Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. If you haven't been in trouble before, and this is your first time getting in trouble, Jefferson County has a program where they will dismiss your case. And if you complete the program, you can get the case expunged from your record. Expunged means erased, deleted, or wiped off of your criminal record. And the way it works is you have to file an application with the district attorney's office. You have to have an attorney to help you with that application. And it cannot be an offense for resisting arrest or unlawfully carrying a weapon. And so if you meet the qualifications, you get into the program, they dismiss your case, you complete the program, you can get it expunged, deleted, wiped off, or erased from your criminal record. If you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office also has a program that is called Veterans Court. It is for veterans only. The only criteria to get in the program is to be a veteran. So if you get into the program, they will, you have to, once you go through the program, they will dismiss your case and you could get it expunged or wiped off, deleted, or erased from your criminal record. Now we have some information here that we can provide you with for those programs if you're interested in any one of those programs that I've just mentioned. Now this court, County Court at Law number 2, Jefferson County, Texas, has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office. This program was started in March of 2017, over 6 years ago. And this program is designed to address the issue of what we call recidivism. Recidivism means basically means people commit crimes over and over. And so how do we address that? Well, we address it through this program that I call the Community Safety Initiative. With this program, we have partnerships with agencies in our community. One of the partnerships that we have is a partnership with Spindletop. Spindletop is our local mental health agency. Now, the program that we have with Spindletop has the abilities to, they can do a private interview either here or at their facilities. They can do an assessment. They can develop a treatment plan, either outpatient or inpatient, to address whatever mental health needs that you have. Now, you do not have to be incompetent, declared incompetent or insane to participate in these programs. You can suffer from depression, anxiety, bipolar, paranoid schizophrenia, well, a whole host of other mental illnesses that a person may have. They can address those mental illnesses. Now, Spindletop also has a program that is called ATAR. ATAR is a drug treatment and alcohol treatment program. And we also have a program with the local Drug and Alcohol Council, who has a program that is called OZAR. It is also a drug and alcohol counseling program. With that program, they will do a screening, an assessment, and you could be referred for either outpatient or inpatient treatment to address whatever issues you may have with drugs or alcohol. If you are unemployed or you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the chemical industry, and the shipping industry. Once individuals are trained in any one of those areas, then they will assist you or assist them at getting a job in the area that you're trained in. If you have not graduated from high school and you like to get a GED, your graduate equivalency diploma, they have a GED program. Now, all of these programs that I just mentioned are free. It does not cost you anything. The only thing it costs you is just taking the time out to participate in the program. And when we talk about time in this court, we do not just give time, we take our time. That is, excuse me, we do not just arrest a problem, we address the problem. And we believe that if we address the problem, we can produce productive people. Why? And if we produce productive people will not commit crimes. Why? Because they have too much time. They have too much to lose. So in this court, I like to say we do not have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And we're trying to make a difference in the community in which we live. So if you're interested in any one of those programs, just please let us know. And the other benefit from participating in those programs, all of those programs that I just mentioned, they are not only just free, but they can be used as community service in your case. So for example, let's say you're in a class getting job training, or you're in a GED program, or you're getting drug and alcohol treatment, or you're getting mental health treatment. Every 1 hour that you spend in any one of those programs can be used as 1 hour community service toward your fine and court costs. And it will be $12.50 that will go toward your fine and court costs. So in essence, you're doing one thing, but you're getting credit for 3 things. The 3 things is you're in the program, you're doing your community service, and you're paying your fine and court costs, all by doing one thing, just sitting in class, learning to get a new job, learning or getting your GED, or you may be getting treatment for mental health or either drugs or alcohol. So if you're interested in any one of those programs, we have some brochures that we would like to give out. We'll be happy to give out to you. Now, at this time, I mentioned to you, we have some individuals who are in the jury box. They're from Spindletop. They're going to come before you. We got Gabby, we have Kelly, and we have Deputy Hinton. It's all here. And then we'll have them to come out and they can tell you something about the program that Spindletop has to offer. Right?
Your Honor.
You're welcome.
Morning. Morning. My name is Steve, and I'm mental health deputy licensed out of the state of Texas. I'm also a commission in the Griffin County Sheriff's Office. Good to my coworker Gabby, and also Kelly. And these 2 ladies are qualified mental health professionals in the Spindletop. The reason we are all here this morning is because the judge graciously invited us in here. He is here to every single person on the bench. But the judge has found, and what statistics prove, is those who have legal issues commonly have mental health needs, such as use disorders, or sometimes provide community resources to help you with difficult. The judge believes if he can help you with these underlying issues, he can get you out of the cycle of arrest. So this may be your first time to be here, maybe your 10th time to be here. There's still hope. What we're offering you today has the ability to change your life. It's going to be up to you. But we're going to need something from you. You're going to need to share that need with us. When you first came in here, I passed out a document. It's a HIPAA protected document. And Gabby is going to explain this document to you, what you can do with it and how you can share that need with us privately without embarrassing anyone.
So sharing this need, not only includes like, the mental health need aspect, but this can be an anxious time also. If you need support from us, if you need somebody here for you, if you need community, like, that's what we're here also for. But also we want, if you have housing needs, if you have job needs, if you have employment needs, anything like that, we want you to share that out with us. This serves as a baseline HIPAA consent, which means it's protected just like your medical records. No one sees this except for us. And this also gives us the opportunity to contact you once in a matter of your choosing, which can be either text message or calling. So just make sure you put that up there, and you're gonna check the box up here which one you would like and put your number up here. But yeah, this allows us to contact you only once in a matter of you choosing text or call. If you don't want to be contacted anymore after that, that's perfectly fine. Also, we won't bother you like that. But a text message, a text or call, you'll receive either from me or you'll receive from one of my coworkers. But it's not an automatic message or anything like that. It's gonna be from one of us. And so this just allows us to contact you once. If you want to keep in contact with us, or you need that support, or you want to just have somebody to refer back to or have a point of contact, we will continue that contact you all. So it's all up to you. This is all of you.
Also, I wanted to present this to you, get it in your hands before you leave here today. It's a flyer. On the back of it, it tells you a little bit about the advantages of the program itself. And on the front, it also has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. Now, shortly, the court is going to go into recess. When they do, we'll be out there. We'll pick up the forms from you. We'll be able to visit with you, and I'll also get this in your hands. Thank you very much. Thank you, Your Honor.
Okay, thank you. Okay, ladies and gentlemen, the paperwork that you have on the clipboard, if you need some assistance with filling that paperwork out, we have our court personnel who will be happy to assist you in filling the paperwork out. This is going to take a few minutes for us to get the paperwork from you. Now, if you need to use the restrooms, we have 2 restrooms that's right out in the lobby, in the hallway area. The one restroom, the men's restroom, is located in front of County Court at law number 3, which is right outside the door to your right. And the female restroom is located on the opposite side of the hall in front of the 172nd District Court. Now, at this time, we're going to go into recess to give our court personnel an opportunity to help you with that paperwork. And also, the folks from Spindletop is going to come by and also assist you as well with any questions that you may have regarding their program. So at this time, we'll be in recess.